I wonder whether they are asking the questions based on the slides or what, but I have two questions there, but make the point of throwing your questions in the Q&A box. And then, of course, we expect the training session to be as interactive as ever. I also want to make the point that we're now on NBA-ICLE YouTube channel. So all our trainings are recorded and stored there, so you can watch at any time at your leisure. It is my pleasure this afternoon to introduce the speaker for today. And the topic is trial within trial. Victor Obara, Senior Advocate of Nigeria, is a legal practitioner known for his oratory, his deftness and prowess. Victor Uguzrumba Oparasan was born in Owerri, Imo State in 1968 during the Nigerian Civil War to Barrister Nathan Anna Malechi Opara and Mrs. Joy Opara, both of whom have since been called to glory. Victor Oparasan, who is an alumnus of Obafemi Awolowo University, OAU, Ile-Ife, Osun State, was called to the Nigerian bar in 1989. He bagged his LLM degree from Obafemi Awolowo University, Ile-Ife in 1991. He is currently the principal of Victor Opara's Chambers, a litigation-oriented law chambers, and an active member of the Nigerian Bar Association. He has worked in various capacities, which include managing counsel SO, ACO and Co, managing partner KC Ikonne and Co, editor Laws of Nigeria project, anchored by the Nigerian Institute of Advanced Legal Studies, situated at the University of Lagos campus, Research Assistant Center for African Law and Development Studies. He is presently the incumbent chairman of the Continuing Legal Education and Practice Development Committee, Nigerian Bar Association Ikeja Branch, Lagos State, a position he has held for over 18 years. Victor Oparasan has numerous published legal articles to his credit. His other professional affiliations include Fellow Chartered Institute of Loan and Risk Management of Nigeria, Fellow Certified Institute of Auctioneers, Nigerian Fellow, Institute of Strategic Customer Service and Trade Management of Nigeria, member Nigerian Bar Association, member International Bar Association, member Institute of Management Consultants, associate member Chartered Institute of Arbitrators, member Institute of Chartered Mediators and Conciliators, senior member Institute of Public Management Nigeria, associate member Chartered Institute of Taxation of Nigeria, associate member Certified Institute of Shipping of Nigeria, member Lagos Court of Arbitration, just to mention a few. Victor Oparasan is also on the panel of neutrals, Lagos Multi-Door Courthouse. He's also on the public. He's also the public commentator and unrepentant human rights activist. On the 8th of December 2021, he was conferred with the prestigious rank of Senior Advocate of Nigeria by the Legal Practitioners Privileges Committee. I must thank you, Leonard Silk, for joining us today. Your enthusiasm and dedication to the advancement of knowledge in the legal profession is legendary. It is not an easy feat to have chaired a committee of the brand, the Continuing Legal Education Committee of the Ikeja branch for 18 years. Thank you for the amazing work you're doing, and it is an honor to have you here today. Leonard Silk, the floor is all yours now. Thank you.
Thank you so much. I'm most grateful to you, and I welcome all our participants to this seminar or workshop. I will just attempt to share my thoughts with all of you with all sincerity of purpose, and hope at the end of the day, we will have learned one or two things about trial within trial. It is important in the first place to define what a confession is. And I invite your attention to the provisions of Section 28 of the Evidence Act, which states clearly that a confession is an admission made at any time by a person charged with a crime, stating or suggesting the inference that he committed that crime. Having said this, it is important to invite your attention to the Black's Law Dictionary, which says an acknowledgement in express words by an accused in a criminal case constitutes confession. When we are in criminal proceedings and during custodial interrogation means when law enforcement agents conduct their investigations, and in the course of the investigation, they take statements volunteered or given by suspects, or non-custodial investigation. That is where a particular suspect has been admitted to administrative bail, and investigation continues. And at the end of the day, statements are taken. Now, when these statements are taken, they are known as extrajudicial statements. Extrajudicial statements. These are statements obtained by an investigating authority from suspects and witnesses outside the presence of the courts, as opposed to a judicial statement or judicial confession, let me put it that way, where a person makes a confession during trial proceedings proper within the presence of a courtroom. When you make an extrajudicial statement, it's actually an informal statement. But when you make a statement in court, particularly a confessional statement in court, it's called a judicial confession. It is important to underscore the importance of a confessional statement during the course of investigation. Well, a confessional statement is made on the strength of that confessional statement alone. If it is positive, direct, urgent, clear, and unequivocal, that particular confession, if voluntary, will ground a conviction against the defendant without the necessity of corroboration. Section 29 of the Evidence Act 2011 underscores the importance of a confessional statement and states clearly that a confessional statement is relevant in the course of criminal prosecution, but gives a caveat that before a confessional statement will be admitted in evidence, such a confessional statement must be voluntary. In other words, it must be a voluntary statement, volunteered by the defendant or the suspect, as at that time, but during court proceedings, becomes a defendant or an accused person. Having said this much, there is a little distinction between admissions and confessions. An admission, technically speaking, you see it more in civil proceedings. A confession will always subsume an admission. And whilst you can see that in civil proceedings, an agent, for example, can make an admission on behalf of his principal. You don't see vicarious confessions in criminal proceedings. Because of the nature of the confession and the fact that it is very, very important in criminal proceedings, there is a lot of emphasis by the courts that before a confessional statement is admitted in law, it must be proved to be voluntary. And that is the reason why it is very important for advocates to be alive to their responsibilities during a trial, so that when you are confronted with an alleged confessional statement, you will know what to do. There are no ways of proving a crime in law. First, eyewitness accounts, where eyewitness witness the commission of the offense. Then you have confessional statements, where a person says, I committed the crime. I stabbed the woman. I defiled the minor. I murdered the victim. Those are cases of clear confessional statements if they are the product of a voluntary act on the part of the defendant. Now, having said this much, it is important to highlight some important things. Because of the nature of a confessional statement, a confessional statement could be written or could be oral. Both of them are admissible in law. It is just that it's easier to tender a particular document or tender a particular written confessional statement and say, yes, this is the evidence that we have against the defendant, and as such, we intend to tender it. If you look at the provisions of the Administration of Criminal Justice Act, particularly Section 15 to Section, and reading right together with Section 17, you will see that even though law enforcement agents are encouraged when a person elects to volunteer a confessional statement to ensure that it's recorded in writing or captured on video, retrievable video, or put in a compact disc after it is made. The oral confession will not be excluded or will not be held inadmissible just because the law enforcement agents are encouraged to make sure that all confessional statements are put in writing. Now we look at the provisions of the Administration of Criminal Justice Law in Lagos State, as amended in 2021. You will see also that law enforcement agents are encouraged to capture confessional statements in writing. And of course, if you look at the amendment, it equally tells you that they are equally encouraged to ensure that when those statements are made, the defendant has the benefit of his legal practitioner in attendance, an adult, a member of the civil society, and several other persons that are stated in the statute. It is because of the importance of confessional statements and the fact that it could grant a conviction without corroboration that it's important for us to understand that in going about this duty, a lawyer needs to be very, very careful and pay attention to his case. In criminal proceedings, by virtue of the provisions of Section 36 of the Constitution, subsection 6, I think paragraph B, a defendant is entitled, an accused or a defendant is entitled to adequate facilities and must be given adequate time to provide his defense. Therefore, it's a case of summary jurisdiction trial, like in the magistrate court, federal high court, or where the case comes on by way of information, where you naturally see the information and you see the proof of evidence usually attached to the information. It is important for a defense attorney, for instance, to be alive to his duty to ensure that first and foremost, he secures the proof of evidence. When you are briefed by a defendant, the very first thing you are going to ask for is the charge. In the magistrate's court, you are likely to be given just the bare charge. You can apply to the prosecution for the proof of evidence. The proof of evidence will usually contain the statement of the defendant and the statement of some other key witnesses. From the proof of evidence, you will be able to see whether a confessional statement was made. The defendant. There is a particular case, the case of Okoye versus COP, which I have just shared. And in that case, the matter arose from the magistrate's court and it went all to the Supreme Court. And the Supreme Court held that whether it's a case at the magistrate court or whether it's a case at the high court, the defendant is entitled to have copies of his statement of other witnesses of the prosecution, and documents that form part of the proof of evidence. So that is the first thing you do. Once you get the proof of evidence, you carefully go through the proof of evidence. Then you'll be able to ascertain whether the defendant made a confessional statement or not. If the defendant made a confessional statement, in your pre-trial interview, pre-trial interaction with the defendant, you will have to ask him, please tell me the circumstances that made you to make this particular confessional statement. If you have his brief to the extent that the statement was involuntarily made, then you're already armed with a potent lethal weapon to destroy the admissibility of that particular statement when it's about the defendant. Now, what are we talking about here? We are saying that the prosecution, in the course of investigation, usually wants to tender the confessional statement through the investigating police officer or through any other officer that was partook in the investigation. And at that point in time, the prosecutor is about to tender the confessional statement to prove the allegation or for the commission of the crime, the defendant counsel needs to be very careful. And at this point in time, the defendant counsel needs to stand up in his feet and wait for what I call the golden hour and the golden moment. What is the golden moment? It is the moment that the confessional statement is sought to be tendered as an exhibit, not necessarily for identification, as an exhibit in the case, as it were. If the prosecution generally will usually lead the witness and say something like, oh, IPO, you are the investigating police officer. You say, yes. In the course of investigation, what happened? You will say, oh, the defendant volunteered the statement. You will say, if you see the statement, will you be able to identify it? You say, yes, I can identify it. Then you will show him the statement. Is this the statement? He says, I can identify it, because usually he may be able to identify it because he probably countersigned it or as recorded. But because of the brief you have gotten from the defendant, that the statement was procured either by duress, force, coercion, intimidation, you wait. The moment the prosecution trusts the paper to the court and tells the court, I seek to tender this particular statement, confessional statement in evidence, at that time you will stand up and raise an objection to the admissibility of the confessional statement. Pardon me. Raise an objection to the admissibility of the confessional statement on grounds of involuntariness. It is not advisable to use generic terms such as we are objecting because the statement is involuntary. No. You need to be specific. The language of objection needs to be specific. The tenure must be categorical. You are supposed to say something like this. No, I'm objecting to the admissibility of this statement on grounds that this statement, I am told by my client, and I verily believe it, that he was coerced to sign the statement. He was coerced to make the statement. He was forced. He was brutalized. At that point in time, once the court hears that objection, the court is under an obligation. It is not a question of discretion, or order what is called voir dire, trial within trial, or a mini trial. That mini trial, as it were, is specifically zeroed at testing the voluntariness of the confessional statement. That is just the purpose of a trial within trial. No more, no less. The court is bound by law. If you look at the provisions of Section 29 of the Evidence Act, particularly Section 29(4), you will see that there is statutory authentication for the trial court to order a trial within trial, which is just a minute trial. I'll come back to that later. It is not only when a defendant raises an objection that the court is mandated to order a trial within trial. If you look at the provisions of Section 29 of the Evidence Act 2011, a court can so much tell the prosecution as a condition precedent to tendering the confessional statement or admitting it in law, in evidence, to prove its voluntariness. So a court can do this so much, and of course, a defendant can equally raise that objection. And so once that objection is raised, then the court is bound, like I said, to order a trial within trial. If you do not raise an objection as to the voluntariness of the statement, at that time, the presumption is that the statement was voluntary and the statement will be admitted. That is the only time permissible for you to raise an objection as to the admissibility of a confessional statement on grounds of involuntariness. It is at the time that the prosecution seeks to tender that particular statement in evidence. And if you look at it, the term of objection needs to be very, very clear, concise. And in certain instances, there's what we call the two-in-one objection. The two-in-one objection is an objection that encompasses a retraction. I'll come back to that later. And of course, it equally talks about involuntariness. Here you have a statement like this. We are objecting to the admissibility of the statement in evidence. The accused said he was put under duress to sign the statement. He never made the statement. Now, if you look at the first part of that objection, it talks about involuntariness. If you look at the second part of the objection, it talks about he did not make the statement. Now, there's a distinction between an objection on voluntariness or involuntariness of the statement and a retraction of a statement. Now, once the objection relates to the fact that the defendant was forced to make the statement, he was coerced to make the statement, he was beaten to make the statement.
No, talk in English.
Okay, company name.
Hello?
We can hear you.
Okay, yes, sorry. Once the defendant raises that type of objection, the court needs to look at it carefully because it is a two-in-one objection and complaint. In other words, if you look at the way that objection is up, you will see that there is an attempt to attack that particular statement on grounds of involuntariness. And in the other part of it, it retracts it. It's a kind of resignment or retraction. If a court does not order a trial within time, then the court has missed the point. Because the tenure and the language of the first objection clearly says that that particular objection is a product of duress, is a product of coercion, and it's not a voluntary statement. Now, let me go back to what I'm saying. Now, when you want to raise an objection as to involuntariness, you will hear things like this. I was forced to make the statement. A clear case of an objection on involuntariness. I was forced to sign the statement. There's a distinction between forced to make a statement. I was forced to sign the statement. Involuntary, that's an involuntary statement. I was induced to make a statement in a particular way in exchange for my freedom. Involuntary statement. I was promised that I would not be charged to court along with other defendants, but I will be made a witness if I make a statement in a particular way. Involuntary statement. I was beaten and tortured. A promise was made to me that all the items recovered will be returned to me if I write in a particular. It's an involuntary statement. Now, when you want to look at a retraction of a statement as it were, you will see that there's a distinction between when you raise an objection that a statement was made involuntarily and when you are saying that a statement was not made by you. If a defendant says, I did not make any statement at all, not challenging voluntariness of the statement, a trial within trial will not be ordered. If a defendant says that I was not the one that signed the statement, it is not a challenge on the voluntariness of the statement. You are actually retracting your statement. If a defendant says the statement was not made in the presence of my lawyer, we are not challenging the voluntariness of the statement. Technically speaking, I'll come back to that. The statement was not endorsed by a superior police officer. That is not a challenge of voluntariness. I dispute the content of the statement. This is not what I told the police. They wrote a different thing. The statement was not read over to me at the police station. The statement was written for me by the police officer. The statement was given to me by the police officer to recopy and sign. I was not myself when I made the statement. All these things do not amount to a challenge as to any voluntariness of that statement. These ones just amount to retraction of the statement. What is retraction? The retraction of a statement usually happens when the statement has gone in. The statement has gone in. The confessional statement has already been admitted in evidence. And the defendant, during the course of trial, now seeks to pull himself away from such a confessional statement. It becomes another retraction. Therefore, it is important to note that you cannot challenge the involuntariness of a statement during address stage. You can't even do it during defense stage. It can only be done at that particular moment. And once you fail to take advantage of that golden moment, it is done. The statement will now be admitted in evidence, and all other things will not follow. Now, having said this, it is important to understand who and who can raise an objection. Now, in a joint trial, for example, where you have several accused, several defendants, it is the maker of the statements that can actually challenge the involuntariness of the statement, not the co-accused persons. Why? A confessional statement is evidence against the maker of the statement. It cannot be used as evidence against co-accused persons, except when, at the period when the confessional statement was made, the co-accused persons or other persons around it, by conduct, or either by conduct or by adoption, adopt that particular statement as theirs. In other words, they authenticate the confessional statement. So because of this, it is important to realize that the objection will legally be raised by the person that allegedly made the confessional statement, not the co-accused. And if you look at the case of Babalola, for example, the Court of Appeal took the position that any other person, particularly a co-accused, who was identified and properly incriminated in such a confessional statement made by another person, could actually object. But when the matter went to the Supreme Court said no. And my Lord, Honorable Justice Akas JSC, in his contributing judgment, said no. It is only the maker of that particular confessional statement allegedly made voluntarily that can raise an objection as to the voluntariness of that statement. Now, it is important to equally realize that the prosecution is not entitled to just tender any statement. The statement that has to be tendered with greatest respect must be in the primary form, the one written by the defendant himself, either in his handwriting or where he had the services of an interpreter, you understand me, or where he had somebody translating it, the original version, how it was produced, and the translated one will have been tendered together. That is the state of the law. And because of the fact that it is a public document, you can only tender it in its primary form, or you tender the certified true copy of that particular statement. Now, if you are tendering a certified true copy, you must comply with the provisions of Section 102 and Section 104 of the Evidence Act 2011 as to what you have to do to have a proper certification. And proper certification means the name of the officer, the name of the officer, his designation, his rank, and everything has to be stated. Proper certification. If not, that statement will not even be countenanced at all. But if it is tendered in the primary form, fine. That means it's the primary evidence itself that is sought to be tendered. Now, in tendering the statement, usually it is the IPO that will usually tender the statement, the investigating police officer. But it's not the law that it is only the IPO that can tender a confessional statement. Any other person that partook in the investigation that was part of the team and who witnessed them, who did the taking of the statement, can tender it. And of course, I've referred to the cases of Emedo at the state, Somi at the state, as you can see on the screen. Now, once that is done, and the defendant has raised a valid objection as to the voluntariness of the statement, then, like I said, a trial within trial would be ordered. Now, let me pause a bit. It is not only all the time that you have written confession. Let's go to oral confession. Oral confession is endorsed in Section 15 of the ACJA, and of course, oral confessions are endorsed in the new Section 9 of the ACJL, for example, of Lagos State. Don't forget that the old Section 9 of the ACJL of Lagos State has been amended. There is now a new Section 9 in the amendment in 2021. It talks about oral confessions. And these oral confessions are equally admissible. Therefore, the same level of vigilance that you need to exercise as a defense counsel, you must exercise it when the oral confession is sought to be given in court. Because if an oral confession is made to an IPO, for example, he has the latitude to give that oral confession to the court, and it's admissible. But if you know that oral confession was a product of force or was involuntarily made, like I've explained before, you need to stand up again and raise an objection that that particular oral confession was involuntarily made, and the court is equally bound to order a trial within trial. Now, this trial within trial is just a mini trial. A trial within trial is just a sub-trial, a trial within the main trial. What happens? The main trial, maybe it's a trial for kidnapping, maybe it's a trial for armed robbery, maybe it's a trial for murder or manslaughter. The judge has a duty to pause the main trial, temporarily, and of course now order a trial within trial. The main trial is suspended and put on hold. The mini trial will not start, and everything you will see in the main trial is equally what you will see in the trial within trial. The difference is that in a trial within trial, the focus of the prosecution is to prove the voluntariness of the statement. The focus of the defense counsel is to establish the involuntariness of the statement. The focus of the court is to make sure that all evidence given is zeroed at one thing, and that is to prove the voluntariness of the statement. No other thing. Therefore, once that situation arises, what does the court do? The witnesses are resworn. Usually the IPO will be resworn. And because of the fact that it is the duty of the prosecution to prove the voluntariness of a statement, it is not a presumption of law. It is this duty to prove that a statement is voluntary, because before it can be admitted in evidence, it must be voluntary. So the onus is on the prosecution and not on the defense. Where courts make that mistake and allow the defense to take the witness stand first in a trial within the trial will be vitiated, sunk down on appeal. Now, so usually it is the prosecution that will start, and usually they will start with the IPO, and the witness is sworn on Holy Bible or Quran or is made to affirm. The evidence, evidence is taken. There's evidence in chief. There is cross-examination. There is re-examination. Documentary evidence is tendered. The prosecution can call as many witnesses as it wants to establish the voluntariness of the statement. The defense is bound. I want to advise that at this point in time, defense counsel needs to be very careful, because this is a time when the police will usually give, or the law enforcement agents usually give a graphic description on how voluntary the statement is, by establishing the circumstances under which it was made. They could give evidence that, oh, the man was relaxed. We even gave him tea. We sat down with him. He confessed on his own. This is a big hall. This is our statement taking room. Not one person can be there. All other officers are usually there. So it's impossible for us to beat him and all that. Now, if that kind of testimony comes against you as a defense counsel, and you allow that opportunity to slip by, and you don't cross-examine on such material points, it becomes a problem. You know why? Evidence elicited, evidence given by a particular prosecution, and you don't cross-examine him on a material point, and these are material points, it's still admitted. In other words, that particular allegation that came, that particular evidence that was given by the prosecution in respect of the voluntariness of the statements remains unchallenged, and it will be admitted. The defense counsel too must make sure that it brings enough evidence to establish the involuntariness of the statement. Then you have where the accused was tortured or was beaten, and there are lacerations on his body, there are telltale signs. You can tell him to open his clothes, his dress in court, with the permission of the court, of course. And you would, of course, you have alerted the court that this is kind of evidence you want to produce, and the court will know what to do. Now, if that is done, you can even bring corroborative evidence. It is very vital at this point to ensure that the defendant that made the statement certainly made the witness. There is no law which says that you must call it, but it's advisable that the defendant, who is actually saying that the statement was made involuntary, which is because is a star witness, is a material witness. Even though the law is that you can call as many number of witnesses to establish your case, but if you don't call a material witness, it's a big damage to your case. Therefore, it is usually advisable to call the defendant to take his witness box, and it gives a graphic description on how he was coerced, how he was beaten, how he was tortured, and several instances of what gave birth to the involuntary nature of that particular statement. And it's advisable to look for corroborative evidence. Sometimes when these police extract these confessional statements, they extract these confessional statements in the full glare of some of the public. Sometimes the relatives of the suspects that come visiting the suspects when it's a case of custodial interrogation, we usually witness some of these beatings and some of this torture. It happens on a daily basis. And those are the witnesses that can come and testify that, yes, this is the reason why we feel that this statement is involuntary. That's what we have in this. Now that takes me to legislative intervention. Now, if you look at the provisions of Section 15 of the Administration of Criminal Justice Act 2015 and Section 9 of the Administration of Criminal Justice Law of Lagos, for example, you will see an attempt by the legislature to water down the reoccurrence of trial within trial. And if you look at the provisions of Section 15, it says that of the Administration of Criminal Justice Act, it says clearly that where a confessional statement is sought to be made, the IPO or the police officer or the agency is encouraged to record it in writing. Is encouraged to record it in writing or to capture it video. Of course, if you go down to Section 15, I think subsection 4 or 5, it tells you that oral confessions, irrespective of that particular provision is admissible. If you look at the provisions of the Administration of Criminal Justice Law of Lagos State, now you will see that the police officers or the law enforcement agencies are equally encouraged to ensure that the confessional statement is in writing. And if it's oral, it should actually be captured on video. Now, if you look at the amendments to the Administration of Criminal Justice Law of Lagos State, if you look at the amendment, I'm not talking of the 2011 statute, I'm talking of the amendment of 2021. It now makes the presence of a legal practitioner desirable. It's not longer a mandatory thing. The word used there is may. And in my opinion, may means permissive and not obligatory. I'll come back to these sections. Now, when this trial within trial is going on, like I said, at the end of the proceedings, just like in a main trial, the defense and prosecution counsel are called upon to make a final written address, in which case, that just like you have your normal written address in a criminal trial, and they are given the opportunity to address the court. If it's a written address procedure, they adopt their written addresses and adumbrates. And at the end of the day, the courts will make a finding. The court will make a finding as to the voluntariness of that statement or not. Where the court makes a finding, the kind of finding that the court will make is quite different from the kind of finding that the court will make when you are making a case, for example, in a no-case submission case. The finding was actually examine all the evidence, ascribe probative value to all the testimony of the witnesses, and the court will now come up with a finding and give a reason for its decision. Once it gives a reason for its decision, it either admits the statement as voluntary or rejects the statement as involuntary. Where it rejects the statement as involuntary, the main trial proceeds. And that statement is marked rejected. Where the trial court admits that particular statement in evidence, it is marked as exhibit and the main trial continues. Now, in a trial within trial, as it is, now one has to be very careful in understanding how it works and the duties of a lawyer in a trial within trial. Now, the duty of a trial in a trial within trial is not to lead evidence to establish the innocence of the defendant as regards the main trial. It is important to adduce evidence to showcase the involuntariness of that statement. So you must have your eyes on the ball. And everything you are fixated upon is how to convince the courts that the statement sought to be tendered as a confessional statement is not a voluntary one. Now, it is not every statement that you can challenge and you expect that there will be a trial within trial. It must be a confessional statement. That is the reason why you must first and foremost have read the statement and think that there is something in that statement that makes it confessional in nature. And that confessional statement will show that, oh, clearly the defendant actually committed the offense. Now, confessional statements are post-events. You cannot confess in anticipation of the commission of an offense. No, you cannot. It's not preemptive. If you must have committed an offense, this offense will have been committed. then you go back and make a confession that, oh yes, I committed this offense. Now, once that is done, then you will know very well that the stage has been set and the trial within trial has started and has completed, and the statement has either been rejected or admitted. Now, in the course of trial, as it were, and this usually happens when you have a situation where you have a change of counsel, and a new counsel comes in and takes instructions from the defendant and sees that, oh, this statement ought to have been objected to. This statement was not actually a product of a voluntary action or conduct from the defendant. What does he do? Now, the defendant is encouraged to retract that particular statement, not retracting it just for the fun of it. It must be something you must do with us sincerely of purpose, and of course, having regard to your knowledge of your duty to the court to actually present your client's case with all truthfulness and sincerity and candor. Now, once that is done, it can either be done while the defendant is giving evidence or even during his address. Not that, sorry, when he's giving evidence. That's usually when the retraction will be done. Now, what is retraction? He now goes to say, oh, I did not make this statement. I did not do this. I did not do that. At that point in time, the evidence has already been admitted, and it is now part of the body of documents before the court. Now, if that is the position, then you cannot challenge the involuntariness of that statement at that stage anymore. You have only retracted the statement. And once a statement is retracted, it means that the court is forced to do one thing. The court will not ordinarily convict on that confessional statement that is admitted without warning itself that, oh, it is desirable to look for some sort of corroborative evidence to see the likelihood of convicting accurately on such confessional statements. And that's what we call the six-way test or the veracity test. And I've just shared with you the case of Aaron's guys, what the court ought to do. A confessional statement is retracted. And that retraction, like I said, is not the one that triggers a trial, but one that comes after the statement has been admitted. You will not see the court will ask itself, is there anything outside the confession to show that it is true? Is it corroborated? Are the relevant statements made in the confession of facts true as far as it can be tested? Was the prisoner one who had the opportunity of committing the offense? Is the confession possible? Is it consistent with other facts which have been asserted and have been proved? Now, this is what is called the six-way test. And you can see that in the case of Philip and of the state, that position was endorsed and adopted by the Supreme Court. Now, it is when the court does this that the court will have actually done justice to the case, will either convict on the confessional statement or not convict on the confessional statement. Retraction does not affect the admissibility of confessional statement. Once you have retracted the statement, it has nothing to do with admissibility. Now, let us say one of the things here. Now, if you look at the issue of retraction, as it were, you will find out that sometimes it is mistakenly done at defense stage, it is mistakenly done at address stage. Now, that is very, very incorrect. It is something you can, when you are challenging the involuntariness of the statement, I've said to you at what time that particular statement ought to be challenged. And once that is done, and the trial within trial is ordered, then you will know very well that at least you have the opportunity to showcase to the court that the statement was made involuntary. In going about some of these things, in the trial within trial, some judges, with the greatest respect, will say, no, let me admit the statement provisionally, and during trial, we can now deal with it and I can pass a ruling on it. No, that is not correct. There is no provision for provisional admission of a confessional statement that has been challenged on grounds of involuntariness. What has to be done is that the trial within trial must be kickstarted and completed. And trial within trial is something that must run its full course. It cannot be terminated halfway. It must run its full course and it must end with a ruling of the court, which is a decision. as it is. And that is why it is important to understand that that particular cause of action is open to the court. And if you look at how business work, you will equally notice that in that trial within trial itself, the court is bound to now take advantage of several decisions of court. Now, what usually happens in a trial within trial is that, like the first speaker said when he was delivering his paper the very first day, you will notice that there are certain things you can use to convince the court that a statement was made involuntarily. For example, the provision that says the confession must be captured on video, the provision that says the confession needs to be encouraged to make the statement in the presence of a legal practitioner of their choice, or a member of a civil society, or even an adult or a relative of the suspect. Where these things are not done, these things could be deployed to your advantage, and the court will look at all these omissions on the part of the prosecution, particularly the investigation police officer, and add it with other things to say, okay, this statement is not voluntary. And that is the reason why Section 29(2)(b) is kept there. What does Section 29(2)(b) of the Evidence Act says? It says that, look, apart from the fact of oppression, because if you look at the provisions of the old Evidence Act, it talks about statements that are products of duress, undue influence, promise, and inducement. You won't see those words not really in the administration of in the Evidence Act 2011. You're likely to see a word like oppression. And oppression is there in Section 29. If you look at the provisions of 29(5), you will see where it says oppression includes threats, intimidation, and of course, treating a defendant in an inhuman and degrading manner. These categories of oppressions are not closed. It could be psychological oppression. So, but if you look at the provisions of Section 29(2)(b) of that same act, it tells you that even the court can say, well, I will not get this evidence, this confessional statement, if there are other things that were supposed to be done or not to be done, which will likely render those statements unreliable. What are those things? Those things are those things that are contained, for example, in Section 9 of the ACJL, which talks about the fact of video recording of a confessional statement and it is being witnessed by a legal practitioner, of course, or the Administration of Criminal Justice Act, which talks about the same thing. So the objection to the admissibility of the statement is not hinged on non-compliance with the provisions of the ACJL. No, the ACJL and the ACJL do not regulate evidence. The objection is hinged on Section 29, that it is involuntarily made. And Section 20, the issue of Section 9 and Section 15, which talks about capturing the statement on video or it being witnessed by a legal practitioner, are points you will use to add to all other facts that you have to demonstrate that the statement was not voluntary. Let me give another example. If the prosecution is trying to prove its case, for example, that the statement is voluntary, there is a practice that is usually being adopted. When a confessional statement is made, it will usually be taken to a superior police officer who will ask the defendant, oh, did you make this statement? He says yes. He asks him those questions. And when the defendant says yes, he made those confessional statements voluntarily, the superior officer will equally countersign it. So usually when the police tenders those statements, and usually they may want to even call the superior police officer. You can imagine where a police officer of the rank of the commissioner comes to testify and says, no, I saw this during interview stage, I invited the defendant, I invited the IPO, I confirmed the authenticity of the statement, I confirmed the voluntariness, I asked him whether this statement was a product of duress, even in the comfort of my office, I relaxed him, and he never said anything. It will carry some weight, even though it is not the law that non-endorsement of a statement by a superior police officer will render the statement inadmissible. It is merely desirable to aid in proving the voluntariness of that statement or the involuntariness of that statement, as it were. Now, in the trial within trial, as it is, let me pause because so that I don't forget this point. You must be very careful in ensuring that while that is going on, you create room for you to appeal if the proceedings is not going very well. Why do I say this? At the time they admit the statement, for example, as being voluntary, it is an interlocutory decision. It is an interlocutory decision as it is. And because it is an interlocutory decision, it means that the rights of all the parties have not been determined. There is now a position where you still need to go back to the main trial and continue the trial, and it goes on full steam as it is. Now, if that happens, you need to be alive to your duties, because being an interlocutory decision as it is, the temptation is for you to think you have the 14 days window to appeal, and if the decision does not go in your favor. Now, that is not totally correct. I invite your attention to the provisions of Section 25 of the Court of Appeal Act. And it tells me that when it comes to interlocutory decisions in a civil case, you have a 14 days window. But when it comes to the provisions of the when it comes to criminal appeals, you have a 90 days window, whether it is an interlocutory appeal or a final decision appeal. But that is not to say that you have that latitude, because it is an interlocutory decision. And usually, when you are doing a trial within trial, you may want to draw a lot of inspiration from the factual situations on ground. In other words, your notice of appeal has to be specific in tenor and language. You may have grounds of appeal that are in law, grounds of law. You may equally have grounds of appeal that are grounds of facts. Once it's a ground of appeal that is on law, you can appeal as of right within the 90 days window. Now, but if it's a ground of appeal that draws inspiration from factual decisions of the court, or question the discretion of the court, or it is not strictly sensu on matters of law, then you need leave of court. And that leave of court must equally be gotten and obtained within the 90 days window. Now, in the going about the appeal as it is, particularly when it has to do with a trial that a statement has been admitted and you feel aggrieved by that decision, the notice of appeal as it is must be signed by either the defendant himself or his legal practitioner. The position of the law in the 2011 Court of Appeal rules was that it is only the appellant that can sign a notice of appeal in a criminal trial. That position changed in 2016 Court of Appeal rules, and is equally as changed in 2021 Court of Appeal rules as it is. You don't need, the defendant need not sign the notice of appeal personally. A lawyer can sign on his behalf. You may want to look at the provisions of Order 17, Rule 5 of the Court of Appeal rules. Let us now go to one other important area that I need to discuss very quickly because of time, as it were. The courts have held in certain instances that there are certain conducts of the IPOs that will make the court come to the conclusion that a statement is involuntary. For example, a question and answer section. The position of the law is that the defendant must be told that, look, he can remain silent or deceive his wife, that anything he says will be used against him, and that he needs to volunteer a statement. It's not for you to obtain the statement. Now, if you look at the case of Jim Osalawu and the state that not shared, the Supreme Court held that it is not proper for you to obtain a statement where the word obtained is used, and probably the police or law enforcement agents are testifying, and they are saying that, oh, we obtained the statement. In the circumstances of that particular testimony, viewed with other things, the court may come to the conclusion that statement is involuntary and not allowed to be admitted. Same thing when it has to do with a question and answer section. And I guess it should be left to tell the story, to volunteer a statement. There will be one or two questions for clarification, but not when you have prepared a question in a particular way. So when you have prepared a question in a particular way, and it's a question and answer session, then clearly it is not going to be a voluntary statement. You see, the categories of what a voluntary statement is and what is not closed. But of course, it is now left for the court and the trial attorney or the defense, the prosecution or the defendant to realize that this duty is something they must do sacredly and to be alive to their responsibilities as it is. Now, what is the import of the absence of an accused in a trial within trial? Now, the position of the law now is that when a court orders a trial within trial, it is not something that has to be done in absentia. The defendant must be there physically, because any other thing will mean that is being tried at his back. And so we encourage to ensure that the defendant is present during trial. and as it were. And the burden of proof is on the prosecution to prove the voluntariness of the statement, not for the defendant to be establishing that, oh, the statement is not voluntary. And that's the reason why in a trial within trial, the prosecution starts first. In some jurisdictions, in some courts, some courts have tried to ensure that, probably to save time, ensure that the trial within trial goes on simultaneously and contemporaneously with the main trial. No, sir, that is not permissible under the law. And there are decisions to that effect. Now, the position of the law is that once the court orders the trial within trial, the main trial must stop, must be paused, there must be a cessation of that one. It is not something you do contemporaneously. And I refer you to the case of State versus Sani, where the court said to lump the trial within trial with a substantive trial is a clear and undisputed violation of the defendant accused right to fair hearing entrenched in Section 36(6) of the Constitution of the Federal Republic of Nigeria, as amended, as the defendant accused will be denied the opportunity of deciding how to present his defense before a judgment is delivered. A trial within trial is a restrictive proceeding, in the sense that it is something that oscillates around a narrow compass. And that's the reason why it is very important for us to appreciate what a trial within trial seeks to achieve. Now, my view, with the greatest respect, is that the legislative intention of introduction of Section 9.3 of the ACDL and Section 15.4 was actually to discourage frivolous objections, as to regards to trial. Almost every criminal trial, as it were, particularly when a confessional statement is made, there will usually be an objection and a trial within trial will be conducted. So I believe that if we begin to give bites, serious bites, to the provisions of the ACJA and ACDL, particularly as regards video recording and presence of a legal practitioner, as it were, then we'll begin to save a lot of litigation time. And sometimes it may not even be necessary to even go into a trial within trial if this thing finds its way into the Evidence Act, as it were. What am I saying? It is very unlikely that a statement that is endorsed by me, Victor Parasina, and signed as voluntary, because ordinarily as a lawyer, if I accompany a suspect for interrogation and I'm present, and I see how the interrogation goes on, and I see everything is okay, no torture, no duress, no inducement, I'm likely to sign. And if you take it to court, it's most likely, once the court sees the signature of the lawyer, as it is, and with the seal of the lawyer, I'm not saying that it's mandatory for a lawyer to put his seal there, because technically speaking, it is not, the lawyer is not the maker of that particular document, it's just like a witness to that document as well. But it's desirable to even put your seal, just to authenticate the fact that you're a lawyer. It's very unlikely that the court will hold that statement was not voluntary. I even believe that that particular provision is actually more potent, and more protective than the video coverage one. Because the video coverage one can actually be manipulated and equally be abused in the same way. An accused could be, a defender could be tortured, and that's what he makes a statement and they will warn him, look, we're going to capture you on video, make sure you behave yourself. And that same threat is still, but of course, if the part of the lawyers, civil society members, justice of the peace is elevated to the status of a provision of the Evidence Act, I'm telling you with the greatest respect, issues of bordering on trial within trial will be ameliorated and reduced, at least to the barest minimum, because the temptation to raise that objection will not be there. You will not see a statement, for example, signed by Tobena as a witness to a statement made by his client, and you want to challenge it on grounds of involuntariness that the person was tortured, because the lawyer is trained and understands what custodial interrogation entails, and as it is. So having said this, let us now go to the point where we need to talk about the categories of confessional statements that could trigger trial within trial. Now, the confessional statement must be such that is direct, positive, leaves no one in doubt that that confessional statement is one that actually incriminates the accused person for the purposes of the charge We cannot be trying a defendant for a charge of murder, and you've taken a confessional statement that relates to a confession of treason. It's irrelevant to that proceedings. And so such things are actually relevant by virtue of the fact that it's only relevant and admissible evidence that can actually trigger and ground a trial that can actually come into play when a trial within trial is going on. Let me round up because I understand I've already used an hour from a timekeeper. Well, in rounding up, as it were, this, I'm sorry, I have to apologize. This is not a topic.
That's it. You can take more time if you need it.
Okay, thank you so much. So basically, so basically, it is very good for us to understand how these things work and how important it is for us to understand how it works either for the prosecution or for the defense. Because basically, once the confessional statement, like I said, enters and is admitted in evidence, on the strength of that one alone, your client will actually even be jailed, fined, and every other thing done. So it is clear to us now that the trial within trial is only triggered when a statement is challenged for involuntariness. A trial within trial would not be ordered where the statement is retracted. The tenure of the objection must be clear. In one of the cases where that I will share with you soon, the defense counsel said, oh, the statement was extracted through subtle means. Through subtle means, that was the language used. And of course, the judge did not understand what he was saying. The judge did not order a trial within trial. When the matter went on appeal, the defense counsel raised the point and said, oh, because of the word said it was extracted through subtle means, it means that that statement was involuntary and the court ought to have ordered a trial within trial. That's the case of Lieutenant Commander Steve Obisi, was the chief of army staff, which I'm just sharing here. So this is what the court said. There will be no need for a trial within trial, where the appellant can clearly demonstrate by nature of the language used to express his opinion that the statement credited to him was obtained by force, trick, or unrecognizable legal ways. In the absence of that, it will be idle for the court to forage out in an attempt to be considered to have done its duties magnificently and according to its calling. So basically, what you need to do is sometimes you don't need to even say that, oh, the statement was involuntary. Say, my client was forced to sign the statement. He was tortured. Look at the time. He asked for his glasses, his recommended glasses to read. They refused. And because of the fact that he had to go, because he couldn't bear the pain, he now had to make the statement. All these are things that would trigger the court to order a trial within trial. And having done that, you will now see that at the end of the day, if you do it very well, particularly when the statement is genuinely objected to, in more cases than not, the statements will be struck down, are not admitted and rejected. Once that is rejected, now it has helped you because it means that out of the three ways of proving an offense, like I said in my opening statement, eyewitness account, confessional statement, circumstantial evidence. Now, if the confessional statement is gone, which is actually important and very powerful, right? The confessional statement is called one of the best evidence that you have in law. Because ordinarily, a sane person, a normal person will not make an admission against his own interests. So there is a lot of force behind the confessional statement. Because if a man says, I killed this man, I did this, I murdered this person, the duty of the prosecution is enlightened. One decision says that it's light as an ostrich feather. That's what one decision says. I'm going to share it very soon. So basically, you don't have much to do. The prosecutor does not have much to do when that is done. Having said that, I've equally said to you that it's not only when you want to tender the statement, there is equally the one of the oral confession, which is actually the same thing. And sometimes too, like I said, when the case goes on, the court can even so moto. And this is why judges, sometimes you listen to proceedings. And because the judge is not a zombie, the judge is dominant litis. He understands the case. And when the prosecution seeks to tender a confessional statement, he can say, no, hold on. You need to establish the voluntariness of that statement for admitting. It's there in section 29 of the Evidence Act, which is an improvement of the old section 27 and section 28 of the Evidence Act that is now defunct, that has been repealed. Having said all this, I want to say with respect that, just to save your time, that when you are doing this, and probably a decision goes against you in a trial within trial proceedings, you must be very careful how you phrase and couch your grounds of appeal. Because usually, apart from the legal points you're going to raise your grounds of appeal, there's usually the omnibus clause, omnibus ground of appeal. In a civil proceedings, you're likely to say, oh, the judgment is against the weight of evidence. That's permissible. In a criminal proceedings, no, sir. There is nothing like weights and preponderance of evidence or balance of probabilities. No, the onus is on the prosecution to prove the case beyond reasonable doubt. So the ground of appeal, when it's omnibus ground of appeal, must read something like this. The judgment is unwarranted, unreasonable, and cannot be supported by the evidence adduced. Sometimes you get to the court of appeal, some justices will overlook it. In some decisions, not couching the ground of appeal properly, couching the ground of appeal that is actually best suited to civil proceedings, and you look at that in criminal proceedings, they will strike it out because technically speaking, you don't have a preponderance of evidence and balance of convenience and balance of probabilities rather in a criminal trial. You must prove it beyond reasonable doubt because that is the onus on the prosecution. And why is this? The general presumption of innocence endures in favor of a defendant, constitutionally speaking. So you see, this topic really is very, very wide. It's not something that can actually be discussed in 1 hour. I've tried as much as possible to touch the salient points, to distinguish between voluntary statement and involuntary statement, to distinguish between a retraction and non-retraction, and of course, what you need to do when the matter gets on appeal. Now, if you look at, I want to close by referring to a case, Udoka's case, where Honorable Justice would have this to say. You know, this is what he said, and this was the admonition of Honorable Justice Divo, JSC. Can you share this slide? And that was the case. This slide. No, the case. Sorry. Sorry, please. I'll share with you soon. Okay, let me just say, in that case, the Supreme Court, the Supreme Court just was saying is that it is important that we play up this issue that has to do with a legal practitioner's presence at the stage that a statement is taken. Because in many cases, statements are extracted, are forced from defendants. And most of the time, the police usually like to use that to actually convict people. And because most of the prosecutorial agencies, or the investigative agencies in Nigeria, the greatest respect, several of them are investigatively lazy. They just beat people, deal with them, and extract statements. And sometimes, too, many of the defendants are not very truthful with their, okay, that is it now. This is what he said. Their confessional statements are most of the times beaten out of suspects, and the courts usually admit such statements. As counsel and the accused are unable to prove that the statement was not made voluntarily. A fair trial presupposes a police investigation of the crime for which the accused person stands trial was transparent. In that regard, it is time for safeguards to be put in place to practice transparency. It is seriously recommended that the confessional statements should only be taken from suspects if and only if his counsel is present or in the presence of a legal practitioner. Where this is not done, such a confessional statement should be rejected by the court. Let me say, this is a wonderful contribution by that eminent justice of the Supreme Court. And if you look at cases like Charles and FRN, that says that non-compliance with the provisions of section 15 and 17, which talks about this presence of counsel and vigil, that the statement should be flung out of the judicial window. And of course, there have been a lot of decisions. Some saying that, oh no, the courts, the ACT, the legislature of the states cannot legislate on every evidence, for example, and that what governs admissibility is evidence, and not is the Evidence Act, and not the administration of criminal justice law. Yes, good point. But my own position, with the greatest respect, is that even where you want to raise an objection, that a statement is not voluntarily made by reason of all this non-compliance with the provisions of the ACJL and ACJA. The objection is not predicated on that. The objection is predicated on section 29.2b, which says that if there's any other aim that will appear to the court Any other thing done or done that will make it likely that that statement is inadmissible, then the court will reject it. That's where you now take a trick to the provisions of those sections and import those sections in section 29. So fill in that gap, as it were. By the time we begin to do this, then we begin to see that our investigative bodies will sit up, the prosecution will sit up, the defense will sit up, and in many cases, it will reduce the prosecutorial time. Because once you have a counsel, like I said, who countersigns a statement and authenticates it, it's very, very unlikely that you will succeed on issues of involuntariness of the statement, particularly when that counsel is alive and his signature is there. It becomes very difficult for you to convince anybody that the lawyer stood and countersigned the statement and endorsed it. At the end of the day, the statement was held to be involuntary. Let me pause because of time so I can take questions. Thank you so much. I'll have loved to speak more because of time constraints. Thank you so much. I hope I'll be able to add some value.
Leonard, amazing. I will comment on whether you've been able to add some value at the end of it all, but do permit me to invite Mr. Rotimi Jacobs for his comments on the presentation or any points that he would like to make. Leonard, the advocate, Mr. Rotimi Jacobs, please.
Hearing me?
We can hear you now, sir.
Hello.
I hear you now, sir.
Yeah, very good presentation, and I must commend my colleague, Mr. Okwara, for that wonderful presentation. Is well presented, well researched, and we are all benefiting from what he's saying, and which makes serious sense to me. He has lectured us more, particularly on the trial within trial, the procedure, the time to raise it. I must commend him. He has shown that he's a trial lawyer, he's a defense lawyer, and he's showing his own side for the defense, which I must commend him. Now, I just want to make some clarification on issues. I just want to make comments on some of the issues that my colleagues talk about. Now, the decision as to what where to raise conversion, where to raise issue of voluntariness of confessional statement. You know, we make a lot of confusion as to mere admission and where a confessional statement is made. It is not just any admission in a statement that constitutes a confession. A confession, according to what he said, which I also agree with, must relate to the charge, must relate to the ingredients of the offense. Where a defendant did not admit the ingredients of the offense, I don't see any benefit of conducting trial within trial. So, but where there is any admission in the statement, many courts will proceed with trial within trial. He has to admit the offense. But the only aspect that I did not agree with my colleagues is the aspect is saying that the conviction will have to be on the offenses charged. Now, there are offenses that are charged. There are offenses that they call me convict that are not really charged with that offense. If you admit lesser offense, are you saying that the conventional statement is made in the latter in the statement there should be no trial within trial? So it's not only the offense that is actually charged, but the offense in which he could possibly have been convicted in relation to that offense. So the example he gave. So I don't think that we should labor too much on that. Now he also talk about where they just make a remark, where to make this issue of there's one case that was on conventional statement. There is a particular authority that is cited question and answer session. Now, my colleagues refer to the case of the whole case of NAMSO and the state. The position of the Supreme Court in that case was that once it is a question and answer, the conventional statement is a product of a question and answer session, that the court should not admit it. Now, later, the Supreme Court reconsidered that decision, and they both agreed that no, the mere fact that it's a question and answer, that there's no police officer who will obtain statement from a defendant, that we're not asking questions, that the fact that the question and answer is involved does not mean that that statement was not obtained voluntarily. So, and there are many cases thereafter, like State and Rabiu, where the Supreme Court reconsidered their position in NAMSO and said, no, you can, it doesn't make it involuntary. So now, so that aspect, I think I don't agree with it, that the fact that the question and answer is involved. Now, another serious problem I normally have in trial within trial is where you have numerous statements made by the defendant. Now, if we look at a number of 4 decisions of the Supreme Court is saying that each of these statements, the trial within trial for each of them must be conducted separately. Now, a defendant make about 7 statements. And in these 7 statements, the decision of the Supreme Court is saying that there must be a trial within trial for each separately, distinctly, for each and every one of them. So I think that it's time consuming. If you are saying that I should conduct trial within trial for one accused person at a time, that makes sense to me. But you now say that accused person, defendant number 1, made 7 statements. I must conduct trial within trial for each and every of those statements. I think it is out of place and sheer waste of time and energy for the court to conduct trial on each and every one of them. But luckily, recently, they are saying that in 2021, in Bende and the FRL, in Berende and FRL, they are saying that, well, if the defense counsel did not raise it and he concede to it, that may not be fatal. But in I felt that that should not be, because if trial within trial in itself, my colleague cited some authority that says that the judge cannot postpone the ruling, cannot. They are in some states of the federation, like Kaduna, like Plateau, like other places, they are saying that the ruling on interlocutory decision, like trial within trial, should be given at the end of the trial. So, and that the court can combine, in some of the ACJL in some states, that the court can allow the proceeding to go on smoothly and allow the prosecutor to lead evidence to it. So I don't see anything wrong with those decisions and those statutory provisions, so as to save time. So why treating conventional statement differently? Can't the defendant just, as the statement being tendered, raise his objection? And when he raises his objection, the prosecution will now lead evidence to prove that it was voluntary. When he's given his defense, he can now lead evidence as to if voluntariness of that statement is a procedure. It's not governed by evidence. So AJA or Administration of Criminal Justice Law state can govern that. It's on procedure. It's not on admissibility. So I think there's nothing wrong in that. The ruling should be given at no case formation, or at the stage of the defense, or at the stage of final address. So I don't see anything wrong in that. Now, my colleagues also said conventional statements that when the prosecution is file his case, it started with that and started the Okoye's case, and said that by Okoye and COP, if it is magistrate court, that the prosecution is entitled to supply the proof of evidence. Yes, Okoye has made elaborate pronouncements under Section 36B of the Constitution that adequate facilities be made available to the defendant. However, for magistrate court, the Supreme Court that decided Okoye in Madugas and the states, now reconsider their stand on Okoye and say, no, the defendant must apply to court. It's not just for him to request from the prosecution or request for that, he must apply to court to ask for those statements. Because ordinarily it's not entitled to those statements. But if he applies in magistrate court, if he applies, then the court will make another forcing him to forcing the prosecution to make available those, because this Supreme Court was saying there are steps to be taken before you can admit the statement of a witness and a defendant, that you lay foundations. But if you need it beforehand, you apply to the court, and the court will be obliged to make the order. So we make available so I have a lot to say, but I don't want to take over so my colleagues have done so well, and I must commend him for a good job, and I really benefited from what he's saying. So thank you very much. Then as to the presence of counsel, let me finish with that. There are conflicting decisions of the Court of Appeal on the presence of lawyer and the presence of the defense. There are not large number of cases where the Court of Appeal gave contrary to that it's mandatory that lawyer must be there, and another breath or a lot of set of cases, about 6 of them also, where they are saying it's not mandatory. Now, I think Supreme Court has settled that in Taiwo's case. Taiwo and FRL. Taiwo and FRL. So the Supreme Court has laid down, made an authoritative statement that the issue as to taking of conventional statements is governed by the Evidence Act, and the admissibility of conventional statements is governed by Evidence Act, and that Section 15(4) and 17 of the Administration of Criminal Justice Act cannot govern the admissibility of conventional statements. So that was the decision of Justice Odili in Taiwo and FRL. So to a very large extent, that one has been put to rest. But he made a passionate appeal that lawyers must be there. Because if lawyers are there, if lawyers are in the statement cannot be challenged. But I assure my colleagues, the cases I have been doing, lawyers, senior advocates sign statement is still challenged for voluntariness of those statements. Where it was video recorded, they still challenge the admissibility of it. Now, I did not agree with him that the absence of counsel or the absence of video recording is not a confessional grant. It's not challenging the confessional statement of that that witness, because those provisions were made to ensure that statements that are made voluntarily. So it's on ground of voluntariness of the evidence of the statement of the defendant that Section 15(4) and Section 17(2) were made under AGA to ensure that if these statements are made in the presence of lawyer, or made in the presence of his relation, or made by the presence of civil society or persons, like it's a grant to challenge the voluntariness of confessional statement of the defendant. So it's a clear grant. So he cannot say that it's only related to retraction or admissibility of that statement. It is on ground of voluntariness. So thank you very much for the Taiwo's case that I cited. Is the 2022 13 Nigerian Weekly Law Report, part 1846, page 61. That's where the Supreme Court resolved this conflicting decision of the Court of Appeal, Taiwo and FRL. Thank you very much.
Thank you very much, Leonard Senior Advocate of Nigeria, Rotimi Jacobs, for your intervention. Thank you. Let us say, Mr. Obara, do you have any comments on that?
Yes, I thank my colleague for that wonderful intervention. Perhaps I should make myself clearer. My position, with greatest respect, that I was pushing for a legislative reform. If you look at the provisions of Section 15 and Section 17, it tells you that in section 15 of the Act says that where a person seeks to make a confessional statement, the investigating police officer shall ensure that the statement is recorded in writing or captured on video. If you move down, it says that this does not dispense with an oral confession being admitted. If you look at the provisions of section 9 of the ACJL as of today, it says that, look, where a person wants to make a confessional statement, it should be recorded in writing, and it should only be captured on video. It's suggesting that this is what you should do. The fact that a statement was not captured on video, the fact that your lawyer was not there ordinarily as of today, I beg to differ from my learned friend, my learned brother Silk, that it will mean that that statement is involuntary. No, sir. It is only a legislative intervention that if it's exported, if it's elevated to the status of the Evidence Act, where it says that a statement should be witnessed by a lawyer or captured on video, it becomes part of the Evidence Act. Then it would then mean clearly that that statement could be challenged on that ground. The issue of capturing lawyer's presence there and issue of capturing on video, some confessional statements are not challenged. It is just for you to be sure that at the end of the day, the court can be able to hold on to something to suggest to it that yes, a statement was voluntary, or to suggest to it properly. It is not a ground to say that I'm challenging the voluntariness of the statement because it was not captured on video. I disagree. I challenge the voluntariness of the statement because my lawyer was not there. I disagree, sir. But it's a ground to say I was tortured. I was dealt with. I wrote the statement. That is the reason why, despite the fact that they have a duty to tell me to allow my lawyer to be there, I asked my lawyer to be there, they did not give me that facility. Then it forms corroborative evidence. I don't share that opinion. And that is the reason why I said to you, with the greatest respect, that most of the decisions that went to the Court of Appeal and the Supreme Court were targeted at the fact that most of the objections were based on Section 9 and Section 54. That is not the way to go about it. The way to go about it is to pigeonhole the objection for Section 29, subsection B, which says clearly, it says that but after talking about oppression, he says, in consequence of anything said or done, which was likely in the circumstances existing at that time to render unreliable the confession. This is an open, caveat that allows you not to say yes, because of so and so, because you did not allow my lawyer to be there, because you did not video record this thing. It is very unlikely that this statement was made voluntarily, in addition to some other things that you have said. Now, another friend equally mentioned the fact that a confession, you can be convicted for a lesser offense. I agree with him entirely. But you see, the trust of my own object, the trust of my paper, was that you cannot be having this, you cannot be confessing for having committed murder. And for example, they are trying you for kidnapping. No, they are trying you for stealing, for example. There's no correlation. Usually when you convict of a lesser offense, as it were, there must be some form of correlation. It's not a blanket power given to a court. Because at the end of the day, you don't just convict a defendant, you understand me, at large. Because you must equally confront the defendant with specific allegations, bring custodial or non-custodial interrogation. You don't charge me for kidnapping, and I give statements of kidnapping, and I address of kidnapping, then you now want to convict me for probable treason. No. There must be some form of correlation. So it's not a blank, it's not a, it does give you that wide latitude. People concede that in certain instances, when you don't convict for a principal offense, you can convict for the letter, but there has to be some correlation.
Hello, sir. Hello, sir. Mr. Okpara, my colleague. Hello, Mr. Okpara, sir.
Yes.
In the event that you was charged for murder, and then the prosecution discovered that after he has tendered that statement, and you said, well, he admitted that he was involved in kidnapping. And after the statement is admitted, he amended the charge and brought in the kidnapping charge. Are you not putting your client's interest in jeopardy?
Interest. That's why I said you don't understand me.
So what section 27 says?
See, if you look at the
offense, admission of crime.
If you look at the provisions of section 29 of the Evidence Act,
Yes.
Are you with me? It says,
Yes,
in any proceedings, a confession made by a defendant may be given in evidence against him insofar as is relevant to any matter in issue. It's so relevant to any matter in issue. And what is relevant is section 29. It says, in so matter as is relevant to any matter in issue. So the issue is this. You cannot, in my own view, now, because of that, bringing a confessional statement in respect of any other thing, I will raise an objection to his admissibility, and I'm sure they will check it out for it being relevant to the proceedings. That's my own view.
Thank you, Leonard Silks. This is a very interesting exchange, and we must find time within the series, maybe towards the end. I've taken the notes to bring you together to look at these issues again. But I just wanted us to be sure that we covered the questions in the box for today. We can take this on some other time if it's agreeable by the two of you. Thank you very much. May I now invite Dr. Onyeke for a brief comment?
This is crossfire. In those days, when you watch CNN, they say crossfire. This is crossfire. I don't know why Leonard Silk decided to off his video. I wanted to be watching him on his when I'm talking now on this crossfire that I just watched. No, not you. I'm talking about Rotimi Jacobs.
Okay.
He put off his video. I would have loved to see his face. You know, I was enjoying myself, honestly speaking. And my simple comment that first of all, let me commend Obara SAN for a very well presented and wonderful lecture. It's like going back to classroom and at the courtroom at the same time, and add mixture of the two. I believe sincerely that everybody who has the privilege to tune in today, and those who did not, in fact, they will tell those who did not tune in today that they missed a lot. So thank you very much, Leonard Silk, for this wonderful presentation. I also thank Leonard Silk, Rotimi Jacobs. I did not expect any less from him. He's somebody who if something is said that is not agreeing with him, he bites his body. He wants to, and it's all about the spirit of knowledge, trying to impart knowledge. And I must commend him also for his contribution. Sincerely speaking, both of them were saying almost the same thing. Just the circumstances that are just slightly different. And but I enjoyed the different angles they were coming from. And having said that, I'm looking forward to when the next Rotimi Jacobs will come on, and I would want Mr. Obara to tune in on that day too. So that yes, exactly. Because I want to keep scores that day.
Yes.
Thank you very much, to two of you.
Thank you, sir.
Thanks a lot, Docs. And indeed, I can see that from the comments that participants were excited with the engagement and the flavor. And that's why we actually encourage panelists to come on so that they give their perspectives to presentations. Thank you very much, Docs. Thank you very much, Leonard Silk, Rotimi Jacobs. And then I'm back to the owner of today's session, Mr. Victor Obara, Senior Advocate of Nigeria. It is question time. So the first question that we have is, the practice direction here in Bayelsa State is to the effect that ruling in a trial within trial will be delivered alongside the judgment. I'd like the Leonard Silk to comment on this.
Well, the various courts are empowered to make their own practice directions. And practice directions, of course, form part of the body of laws. But I have my own reservations about that practice. The reason is this. The administration of criminal justice laws and the Act itself actually encourage speedy trial of matters. And if you look at the provisions of Section 36, the Constitution, it equally talks about the accused having a case heard within a reasonable time. that doesn't mean you sacrifice his rights as a defendant because of the penal consequences and the fact that he can lose his freedom on the altar of haste. Justice rushed is justice crushed. The position is this. If you allow the thing to be taken together, the defendant will be prejudiced. And I'll tell you the reason. If you admit a statement, if you refuse to either rule on the statement, and you are not going to take it at the end of the final address, after you have taken it with the main case, if that's what the question is talking about, then you have a lot of problem. Because you will not know whether the statement will be admitted or the statement will be rejected. And when you are not doing your final address, you are limiting yourself to admitted evidence, admitted documentary evidence that are clearly marked or rejected. You will find your situation whereby your argument will be bifurcated, assuming without considering that the court admits that. It will not allow for the flow. That means at the end of your final written address, you'll be speculating. And aside from that, because of the penal consequences involved, we are talking of a confessional statement that can get you to jail. Now, my understanding of the law is that if a confessional statement is positive, direct, and cogent and believable, it will grant a conviction. In other words, at the end of the day, you are allowed to exercise a trial within trial, and the ruling is given immediately. Usually, criminal trials run on fast track. If it's an interlocutory appeal, you use the fast track procedure for interlocutory appeals. And I'm sure that if you are fairly diligent, by the time you even finish the main trial, as it were, particularly when it has many witnesses, you will have been able to get to the court of appeal. And the court of appeal will probably have struck that statement. In other words, by the time you are now addressing the court finally, that statement will not be there. That's one of the disadvantages of suspending the ruling on it. But I don't see any big deal in a judge writing a bench ruling on a trial within trial. Because the issues are very narrow. The issues are just about the voluntariness. And these issues actually no, except where, and usually in trial within trial, it's more of evidence of the IPO and the team that took the investigation and one or two corroborative evidence. So I don't see in a normal case a prosecution fielding more than 3 or 4 witnesses and the defense fielding 5 witnesses. And what is the, so I believe sincerely that that particular procedure, though could be commendable, in some instances highly prejudicial to the defendant because you would not know the outcome of that particular statement. And at the end of the day, if at the time that the is taken at the end of the trial, the conviction comes, he goes into jail and he now appeals generally. No, I don't think that would be fair to the defendant. I disagree with that procedure, even though being a practice direction, you must obey it as it were, because judges have powers, the CJs have powers to make those practice directions to amplify the convictions of the ACJ. That's my answer.
Thank you very much, Leonard Silk.
Can I say something on that?
Yes.
Okay.
Can I say something on that?
Okay. Yes, Leonard Silk.
It's not practice direction. It's not practice direction alone in the state that introduced that provision. It's in the Administration of Criminal Justice Law of about 10 states in Nigeria now that the ruling on a no case should be delivered at the head at the final address. And I've expressed my opinion on that. The intention is to cut short the period.
No case.
The intention.
We're not talking no case.
Is there? Is there on the no case submission?
No.
I have it. I wrote something on it. Trial within trial. That's what I'm saying.
Yes.
Yes, trial within trial. The intention is that trial within trial should not take much time and should not be. We have instances where we conduct trial within trial for 3 years in some criminal cases. So the intention of the legislation was that in order to avoid this delay, let the parties give evidence and the court at the end of the day deliver its ruling. My objection only to that is that at the point of considering the case of no case submission, if it is raised by the defendant, and the ruling has not yet delivered on the admissibility of the conventional statement of the defendant, what would the court do? Because conventional statement is part of the prosecution's case. Is he going to look at it to decide whether a case has been made out, or he will await a view until the final address. So I always tell them, deliver your ruling before you give your submission, your ruling on a no case submission, so that you will know the extent of evidence that the prosecutor has before you can rule that there is a case to answer or there is no case to answer. Because in Nigeria, the practical thing is that the bulk of this prosecutorial case in Nigeria are conventional statement, admission. Then he has made conventional statement. Police will stop there. So now, if you don't rule on that, how will you be able to decide whether there is a case or no case? So I think the court should read up those provisions in those states to mean that ruling must be delivered before the no case submission ruling is made. That is after the closure of positions case.
Thank you very much. Perhaps a case for yes.
If I may just, I think I saw that when Leonard Sick Rotimi Jacobs was making his submission right now, that Leonard Sick Victor Barra was perhaps thinking that he was not addressing the topic he was supposed to give a presentation on. But that is not really what Leonard Sick Rotimi Jacobs did. I think he was just trying to support Victor Barra's position that there should be a ruling on trial within trial, so that if at the end of the day the defendant makes a no case submission, the court to be in a better position to give a ruling on the no case submission, having ruled on the admissibility or otherwise of the confessional statements that were challenged. So it means it's the same. It's trying to support Victor position. But perhaps Victor is looking at the use of the word no case submission to think that was where he's going.
I think that when he landed,
when he was finishing, I later understood what he was trying to say, and that is just giving Philip to what I said. That the court will not have the benefits of credible evidence to act upon at that stage, and to rob the defendant of his right to exercise a speedy appeal, knowing full well that a confessional statement alone without corroboration can send it 9 months.
Yes, and I like the fact that we are discussing this particular topic, because what it does is to say that on many levels, that particular approach is very faulty. And there could be, if we have as many as 10 states that have that in their ACJL, then we might look at a suggestion, even at the NBA level, for an amendment to those laws. Because Mr. Barasan is even talking about uncertainty on the part of the accused as to what his fate is, because a bench ruling was not given quickly on the matter. But then Mr. Rotimi Jacobs takes it further to say, when there are the no case submission application, what do you do? So on many levels, I think there's a challenge there, and we'll have to take that down. Docs, we need to take that down and push as much as we can to see that it's regularized. Thank you very, very much for this. The next question is, what happens in a situation where the defendant has given confession before you were informed as his counsel, and when you speak to your client, he said that he was coerced or forced to give confessional statements?
Okay, well, the position is very pathetic and very unfortunate, and that is why it is very good that when you are undertaking criminal litigation, you should be at your best. And once you are not at home with the do's and don'ts, it's good to seek the services of colleagues so that at least they could put you through. That's the whole essence of collaboration in this professional arts. The moment you do not raise an objection to the involuntariness of that statement, don't forget that when plea is taken, you are asked whether you can speak English or not. If you cannot speak English, you are entitled to an interpreter constitutionally. So they will ask you whether you understand the charge. You say you understand the charge. Do you understand the proceedings? You understand it. That is where you are defending yourself. When you are defending yourself. But if you are defended by a lawyer, this is a calling that expects the lawyer to be at home with the do's and don'ts. So where the statement has been admitted either because of lethargic attitude on the part of counsel, ignorance, inadvertence, or whatever, the statement has already been admitted and marked. Therefore, it becomes a problem. And now, the only thing you will do now is that you still have a chance to introduce that instruction you have. Because at the time that you took this case up, most probably the defense has not been called upon to come and enter his defense. So during the defense, he will now graphically state the circumstances, how he made that statement, and what led to that statement. This is actually what is called a retraction. The moment you do that, the inconsistency text, inconsistency rule that applies in civil proceedings, where a witness statement in extrajudicial statement is in conflict with what it says in court, which is a judicial statement. If it's the inconsistent rule, they'll say, look, this witness is unreliable. But that thing does not happen in criminal trials. The accused has a right to retract from the statement. What does the court do? Before I convict, I should now, and that's what we call the six-way test. I sincerely believe too, with the greatest respect, that the provisions of the Evidence Act, Section 29, could equally avail. Because if you look at Section 29, that talks about oppression, and if you look at Section 29, subsection 2B, it says, in consequence of anything said or done which was likely in the circumstance existing at that time to render the unreliable any confessional statement. That is where Section 9.3 of the Evidence 9 of the Evidence Act and Section 15 the Evidence Act comes into of the ACJA and ACJL comes into play. Now, but for the decisions of courts, like my learned brother Sika stated, and I've actually settled some of these issues, I believe with the greatest respect that could have been a window to challenge the admissibility of those statements. Because usually, what usually happens is that when people raise objections, rather than raising the objection under Section 29 of the Evidence Act, they will raise the objection under Section 9 or Section 15. Section 15 is a procedural requirement. Section 29 is the Evidence Act. So, but if the objection had been something like this, I'm relying on Section 29 of the Evidence Act, and I'm saying there is something not done by the investigating police officer, which should actually trigger this court to hold that this statement is unreliable. That is that thing. They have a duty to ensure, that is the word used, that the thing is video recorded. They have a duty to ensure that this lawyer of his choice is there. They have a duty to ensure that even if they don't have a lawyer, a member of a civil society, if they don't have a member of a civil society, they have just a member of the justice of peace or any other person. Now, if you have a statement and you don't do all this, you have a duty as a police officer to do this. These things were in the judges' rules, which have been accepted here and codified in the ACJ and ACJL. You could actually argue that way and say there is. And I believe that that's why the Supreme Court, with the greatest respect, came to the decision that, oh, what governs Evidence Act, what governs admissibility is Evidence Act, this thing. No. You are not raising the objection on Section 29. Section 20, on Section 9 or Section 15. Section 15 and Section 9 are feeder provisions to give meat and bite to that. Going back to the question, once they do that test, once you have raised that objection, because if you don't let it go, it will mean that if you don't raise it at the defense stage, it means you have accepted the voluntariness of that statement. Don't forget, when I was making my statement, I said to you that if you don't challenge a voluntary statement, there's a presumption that you agree that it was voluntary. And once you begin to agree that the statement is voluntary, it means that probably you make it without coercion. If you make it without coercion, it means you are speaking the truth. And if you are speaking the truth, it means you are giving evidence against yourself. It becomes very, very worthy evidence usable by the court to send you behind bars. But once you introduce the retraction as briefed by you, the court will be very, very willing to convict solely on that confessional statement without running it with this six-way test and coming to a conclusion whether to ascribe probative value to that statement or to not to ascribe probative value. Thank you.
Thank you very much, Leonard. So, Yes.
Can I
Yes.
just say one or two things here, just to Lenesik?
Please.
I know Lenesik Vitobara very well. We are. How do I put it now? We are buddies. You see, I know he's a teacher at heart, and if you give him chance, he will not leave here by 7 o'clock. So I want to beg that, because we have time constraints, as you can see, that maybe today is a Friday, and some of the juniors may be operating from their office and want to go home. The next set of questions asked is just give bullet points responses to them, so that I take as many questions as possible.
So you know that we will always close at 5 p.m.
If we can extend, no problem. But I'm just saying we should.
No.
If we can extend.
I agree with you completely. We also ask the back office to take a screenshot of all the questions. So that's given when, even if we don't deal with all the questions today, if you would oblige us subsequent answers to them, we can also circulate them so that those who have the questions can have the answers. Thank you very much. So we'll just take one or two more questions. I was also going to mention a commentary that I read on the comments box, which I found quite interesting. The gentleman, Andrew, referred to the session as educative and entertaining, and he called it entertainment. I found that quite interesting, and I said to share it. Okay, so the next question is, thank you so much, sir. Please, what happens when an objection is raised as to the admissibility of involuntarily made statement, but the court failed to conduct trial within trial and admitted the statement and marked the same statement as an exhibit?
Okay, well, good question. Immediately that is done, you have a valid ground of appeal, and quite honestly, if it's escalated speedily, the confessional statement that is admitted will certainly be expunged from the records. I just want to be very brief.
Very good, thank you, sir. The next is, my question is this: can a person or witness who is not in the proof of evidence testify in a trial within trial?
Pardon me again.
He says, can a person or witness who is not in the proof of evidence testify in a trial within trial?
Well, the position of the law is that generally all the witnesses that you intend to rely upon, particularly from the prosecution, you need to front load them and you need to know them. But practically, it is not it's a favorable objection, because if the prosecution decides to bring in their own witnesses for trial within trial, as it were, certainly the front-loaded thing it is has to do with the main time. The prosecution is not supposed to, ahead of time, know that you're going to challenge the voluntariness of the statement or not. So you're not likely to see a proof of evidence specifically listing witnesses for trial within trial. It's not a new charge. It's the same charge as well. So you are entitled to field any witness you desire. If you feel that a particular person, because the witnesses on the main charge need to be witnesses for a trial within trial. And the prosecution is not expected to feel that, oh, you are going to raise an objection. That will be acting clairvoyant. That will be acting clairvoyant. So basically, I sincerely believe that it need not be limited to the witnesses that are stated on the proof of evidence, as it were.
Thank you. The next question is, what is the effect of having the signature of an interpreter on the defendant's confessional statement when the statement was not interpreted to the defendant?
Well, it's a question of proof. It's a question of proof, and it depends on whether the defendant is claiming he's an illiterate. If nothing was interpreted to him, as it were, because usually what normally happens is that when a person claims that he cannot read or write, is either the police officer will help him to write and interpret to him and sign, and is made to sign. But if he says that no, it was not interpreted to me, you can't challenge that. You can't challenge that statement on grounds of involuntariness. You are simply saying that something was not done. That is retraction, and that will not go to the weights to be attached to the statement itself. It is not a ground to reject the statement for involuntariness.
Okay, so the next is, how is an oral confession tendered by the IPO? Is it via an electronic recording or orally in court?
the position of the law is that the IPO testifies when you are going in a trial. There's usually documentary evidence and oral evidence. And if it's an oral confession, he says that this is what I heard directly. It was said to him. A confession was made to me. You understand me? And is tendered that way what he heard. But if at the same time it was recorded, as it were, on video, as it were, that means that takes it into another level. But the oral confession that I'm talking about is the one you go and say, look, IPO, I killed this man. This is how I killed him. I strangled him, and give a graphic description. The IPO has power to come and testify that an oral confession was made to him, and if believed, we can send the man behind bars.
Thank you very much, Leonard Silk. I think that would be a good point to. But Leonard Silk, Rotimi Jacobs, do you have a comment to make?
This oral conversion is a problem we have presently, where video recording is tendered. You see, a lot of our colleagues, when they appear for the defense, they challenge the recording rather than the voluntariness of evidence given by those witnesses in the video itself. So the challenge is not on the content of almost all the cases I've done. They will not go into the content. That's the fact that they have been served with the oral conversion made in video. They will not challenge the voluntariness of those oral testimony or those oral conversion, but dwell more on the admissibility of the disc or where it is recorded. Whereas the fact that it's oral does not mean that it cannot be involuntary. So oral testimony, oral conversion also can also be challenged on the ground that it is made involuntarily. So people should make that distinction. They have to challenge the content of what is recorded. So if a policeman comes and says, this is what he told me, it's not just to deny that I did not tell him that. So you have, if it is true that they can't believe the policeman, and you did not challenge the follow that, well, even if I made the statement to him, it was not made voluntarily. So you can also challenge that on the ground that was not made voluntarily, even the oral testimony, the oral confession. Thank you.
Thank you very much. At this point, this is where we draw the curtain. On behalf of the Institute of Continuing Legal Education of the MBA, I must say a big thank you to Mr. Victor Opara, Senior Advocate of Nigeria, for the industry, and I think I picked that word from the comments box, that and the nature of the presentation. Very well done, sir, and very comprehensive, detailed, but delivered in as simple a form as is the case today. So thank you very much, sir, for indulging us today. We're always grateful to you and to all those who do what you've done today, because it's giving of your time at no recompense for the benefit of your colleagues. And I think that we should all continue to show our gratitude to you and to the other tutors. I am also very grateful to Educat Drox Onyeke, who has been coordinating the sessions and who has found time to be with us at all the presentations and to make his contributions and help with moderating. Thank you very much, Docs. Very grateful. To Leonard Senior Advocate Rotimi Jacobs, what a day, what a day. Very interesting, very fascinating. Your perspectives were very
Keeps running away with this video. I don't know.
Let's say it's just to tell you that any day when we don't see you in Wahala.
He knows I like to see him. I don't know why he keeps running away from me all the time.
Let's see, any day when we don't see you and we don't see Mr. Opara and Wahala, Mr. Opara cannot come only on the day of his presentation.
I will stand in the middle of the two of them.
You have to figure out that days.
But thank you so much.
Thank
you so much.
Yes.
It's interesting. Thank you for affording me the opportunity to share my thoughts. All the criticisms were constructive. It's just an exchange of ideas, cross-fertilization of ideas, and the monopoly of knowledge is not exclusive preserve of anybody. I'm humbled. Thank you so much. produced.
Thank you very much, sir. Thank you very much to everyone. Thank you very much to all those that participated. A lot of people talked about the slides. We normally circulate slides after a set of training. So by Monday, you get the slides for the first 6 sessions we've had. You'll get for the rest at the end of the training sessions. A few people complained about the audio at their end, but the audio was very good from where I'm sitting. But then just to remind you that we have a YouTube channel, NBA-ICLE. All the recordings, over 50-something recordings, are already there. So just go to the playlist section and you can view this particular today's presentation and all other presentations. So thank you very much for joining in. We reconvene again tomorrow at 12 noon for a 2-hour session. So see you all tomorrow, and God bless you. Thank you.
Thank you so much.
Thank you, Lenesik Victor. Well done.
Thank you so much. Thank you so much.
Thank you, Docs. Good to see you always. Thanks. Thank you, Mr. Jacobs. Thank you, Sarah. Thank you, Wally. Good. All right.
Thank you. Yeah, thank you, sir.
Okay. Bye-bye. Wally, you can shut down now. It's time to go.